Welcome to Education in Focus. I'm your host, Eliana Kernodle. Arkansas is getting support from attorneys general in other states for its LEARNS Act after a federal judge issued an injunction against it. Joining me to discuss this is Chalkboard News editor Brendan Clary. Brendan, to start us off, can you give us the background? What is the LEARNS Act?
Yeah, so the LEARNS Act was kind of a widespread law that was passed last year, I believe, where they expanded school choice and they kind of got a lot more, some raises for teachers, just kind of like a widespread, like sort of educational reform bill. But then part of that, and what's in court still with this, is the ideological component of that. So it limited teaching about critical race theory, right? So that's been something I've written quite a bit about in terms of the ideological divide on critical race theory. So there's been a number of states really since, I think, a Trump executive order. Then there was some people back in 2020 that started talking about critical race theory in a negative way, trying to sort of raise awareness about its tenets, what that means, like kind of that worldview and that sort of, it's a legal framework technically. Like that's, the proponents of critical race theory say it's not being taught in K-12, so that these are kind of overkill measures, right? And then it's really sort of like a higher level understanding of the world in a legal system. So that's kind of what this fight ultimately boils down to, is like sort of this larger cultural contention over like how bad is critical race theory. And so that's something to like that's been going on for a number of years now. But then it sort of like manifests itself in different ways, right? Through schools, school boards, and then some of these statewide, limitations on what should be said, right? So I think one of the first notable states to do this was Florida. You had other states that were kind of taking this up and passing laws or legislation or executive orders that were sort of related to this and saying we're not going to allow critical race theory in schools. So that is, and there was an executive order from Sarah Huckabee Sanders, from the governor, and basically saying you can't do that. And there's a separate thing from the LEARNS Act, right? So that was Section 16 of the LEARNS Act, which barred the promotion of, quote, teaching that would indoctrinate students with ideologies such as critical race theory. So that was challenged in court by 2 teachers and 2 students. And they basically said that they would be self-censoring and that, they would deprive them of being taught things that, that they would need to know, right? And maybe deprive them of like certain educational benefits because of that law. So, and then a district judge granted a preliminary injunction saying the state could not enforce or implement that section, right? So that's kind of the backdrop there. And
does this injunction affect the executive order by the governor?
It does not. So that's a great question. That injunction does not affect the executive order issued by Arkansas Governor Sarah Huckabee Sanders in January 2023, which bans the teaching of critical race theory in schools there. But it's based on a similar kind of thing. So I think that the court's not challenging that because of the nature of this lawsuit. Like in the law, you can challenge certain things certain ways, and to challenge the executive order would probably have to be a different way. So, there's more of a limited scope there. So if this lawsuit does work, I don't think that you could go and teach. I think that executive order would still be binding, it sounds like, potentially.
So after this injunction, the state's appealing, and attorneys general from 14 other states have supported Arkansas on this. How are they doing that?
So, if you're a related party, essentially, or you have like kind of a stake in a lawsuit, you can file what's called an amicus brief, which is a way of saying like, hey, we support somebody who's saying something that it's basically saying like, we have skin in the game. We would like to file this to show like, here's another legal argument, and making a case that the court will review when they're making these kinds of decisions. So, you saw this with the Title IX, for example. You had a lot of attorneys general weighing in, a lot of organizations on both sides, right, saying for or against Title IX rules from the Biden administration. But you saw a lot of these amicus briefs, and it's a way to sort of say like, hey, this is what we think. This is good law. This is good jurisprudence. Like, this is what we think the arguments are here constitutionally. So, I think it is notable that 14 of these states came together and said, hey, like, this is what we think about this. A lot of these are Republican leaning states, but, with their attorney generals sort of leaning that, but basically saying that critical race theory openly encourages discrimination based on race, right? So they're going in there and they're saying, here's our argument. And specifically too, like the question comes into like, how can the government control what is being said in schools? Right. So, and is that consistent with the, meaning of the First Amendment, like as it was originally intended? So it starts to get sort of really legally kind of complicated. How much control should the government have over the kinds of speech that the viewpoint that it is promoting, right? So like, and then how do you kind of control that in, like, how do you balance the First Amendment with like the needs of like the educational system? So it starts to get into very complicated sort of terrain there. And a lot of it is about a specific decision from like the 1970s. And they're kind of arguing that that's not good case law, and that should be overturned. Like the court should see through that. So it's like kind of this stuff usually gets really into the nitty gritty really fast, but the ramifications of it are extremely important because it comes down to like, should we teach critical race theory in the classroom? Like, should students have these kinds of things brought up because the teachers felt it was important or because students felt it was important to have? And essentially, in the case against the law, by these two teachers and these two students, they're saying that like, we should have this in the classroom, right? So if they're right, then who gets to determine? So this is sort of the question before the court is, who gets to determine what should be taught in schools and who gets to determine what is taught? And so the attorneys general and the argument that they file, the amicus brief that they file, they basically say, it wouldn't be workable for students to be able to define, like, here's what the government should be giving to us in our thing. Because they kind of hold the government in a place where, maybe you have to have like a specific course that could be wild, based on like a video game or something. I think that was specific, like one of the specific examples they talked about in the amicus brief. Like, could they have like a Call of Duty based like course in high school? And so that it's kind of a funny thing, but it's like one of those questions of like, who gets to decide, and can students just say we have this right, and then try to get the government to do that through the lawsuit. So it's an interesting sort of question, but it has a lot of ramifications.
Well, Brendan, thank you for your insights on this story. This latest story was covered by Kim Jarrett, an associate editor over at the Center Square. And listeners can continue to follow this story as it develops at chalkboardnews.com.